right, shall we begin? Everyone all set? Well, thank you for coming to what is our recurring programs of what we think of as cutting issues in law and technology. We do this on a more or less monthly basis, slightly irregular based on obviously coordinating many schedules, but we're delighted to have all of you here. Professor Steinfeld and I were talking about how many of our students we see here, colleagues, friends from the bar, and it's really a pleasure to entertain you and to have what I think is going to be a very interesting program. It's for those of you who, I assume all of you are here because you're following the fact that there have been big changes in privacy law. We've had the European General Data Protection Regulation kick in on about a year and a half ago coming on now, but the impending one that's happening right now, the more live issue, is the state of California passed the California Consumer Protection Act, otherwise known as the CCPA, which will go live on January 1 of this year. We wanted to provide a program to give you a variety of perspectives of what that means for the companies that our colleagues here are members of the practicing bar are advising and making this transition. How Professor Steinfeld, who is the Chief Privacy Officer at Penn Medicine and has been the Chief Privacy Officer at the university as a whole, is facing, and Janie Lau as it's a long title, General Counsel, Chief Legal Officer, and I'm sure I'm missing some other aspects of it, for InterDigital to bring the perspective of a company, which I think is in many ways is a vital perspective to have here as well. I could talk about their many distinctions in their backgrounds, but at the risk of doing them injustice, I think I shall waive that, leave you to your good office of exercising your ability to read, which you've been well versed in since you were young, and we will turn the floor over to Seamus, who will start us off, introducing us to the wonder that is the CCPA.
Thank you, Christopher. Thanks, Christopher and Lauren, for putting this program together. This is actually the brainchild of one of my partners who's here today, Meredith Slaw, who's a Penn graduate. Basically everything we do right now is CCPA. Starting about 2 weeks ago, people are truly freaking out about all the work that needs to be done between now and January 1 when this law becomes effective. And Meredith is one of the leading lawyers in the country dealing with these issues. And so it's almost been comical over the last couple of weeks how crazy things have gotten. Meredith made the horrible mistake of getting pregnant at a time when his baby is gonna come like around the effective date of this statute. I don't know what kind of maternity leave that's gonna be, if any, but I agreed to stand in today to do this because things have truly just been round the clock for us. So this is the first comprehensive data privacy law in the United States, the California Consumer Privacy Act. And the United States really, if you look at us over the last 20 years, has kind of been the Old West when it comes to data privacy. And what you have seen develop with the ad tech business and with social media is a really, truly gigantic converging ecosystems of data that are fueling just an enormous economy. And whether it was Cambridge Analytica or the 2016 election or the Equifax data breach or whatever it was, the revolution is upon us. And it has come from California. Now let me say right up front, we've already got laws coming through in Massachusetts and in New York. My partner, Ed Pagano, is here. Ed was Senate liaison for the Obama administration. He was for many, many years the senior staffer for Senator Patrick Leahy. When we get to the part of the program where we talk about what's going on in Washington, hopefully Ed will agree to contribute. But we're at a very interesting time in privacy law because we've got this California statute that's coming into effect January 1. Things are hot in Washington, but most people are saying we're probably not going to get a federal bill. And so what we're likely to see is kind of a web of state laws. And our practice with Meredith and I, and also Mike McTighe is with us today, is sitting next to Meredith, my partner. is we represent companies in class action litigation under these statutes. So typically what we've seen in privacy law is kind of a creeping regulation in the country. There's been isolated states, somebody passes a biometric statute, the FTC flirts around with doing something and then sort of typically never does. And then we had the overhang of the General Data Protection Regulation in the EU that took effect in 2018. And that, I think, really spurred many in the United States. And again, some of these incidents, Cambridge Analytica, whatever, pick your crisis. California, the story of how this statute came to be is interesting. A real estate developer in Silicon Valley named Alistair McTaggart. And he's got a ton of money, very successful, very pragmatic, not particularly an activist, left or right. He was having dinner at his home in the Oakland Hills one night, and he had guests, and one of them was an engineer from Google. And the wine was flowing, and the dinner finished, and they were having after-dinner conversation, and he said to the Google engineer, "Should I be worried about what Google knows about me?" And the Google executive made the mistake of the century, right? Again, maybe it had a few too many glasses of wine, but he said, "Oh yeah, you should be very worried." And from that conversation, Alistair McTaggart, previously politically uninvolved, became a zealot for privacy. And he gathered a group, works with Askan Soltani, who was a FTC staffer, was involved in the investigations, the early investigations of Facebook and Google, surrounded himself with really smart people, and they put together a ballot initiative, which in California is you put forward a statute, and it goes on the ballot, and voters get to vote on it. And when Silicon Valley realized where they were, that there was this ballot initiative, and the ballot initiative would have been much more of a disaster than the CCPA will be. And what he did was he negotiated against the deadline for the withdrawal of that ballot initiative. So he said to Silicon Valley, "Tell you what, I'll agree to a statute, we can put it before the legislature and it'll be adopted. But if we can't reach agreement on terms for what that statute will look like, then my ballot initiative is going to go forward." So many people, the lore is that the statute was written over a weekend. That's not really true, but it was written pretty hurriedly in the spring of 2017 and 18, pardon me, and against the deadline for that ballot initiative to go live. And in the weekend before the deadline, there's very dramatic stories, you can read about them online, about the final negotiations for what the CCA will be. So it's kind of like the GDPR, but there's some important differences. Let me go through the just high level, and then I don't want to take too long because the discussion is going to be way more interesting than me just talking. So the statute is organized around the creation of these powerful consumer rights. And so the first we call the right to know, or the requirement of transparency. So this statute is probably the biggest forced speech regulation in the history of Western civilization. Companies all around the country are rewriting their privacy policies for this statute. Statute requires very intricate, detailed disclosures about what you collect, how you collect it, how you share it, and how you use it. So, and the privacy policies also, the statute also requires that you inform California consumers of their rights under the statute. So the right to know is core and fundamental to the design of the statute. The second is the right of access. Now, basically the whole statute proceeds on the concept that you have an inalienable right to your data. And that's a pretty strong statement, inalienable. Non-waivable right to control data about yourself. So when I buy a blue button-down collar shirt from Brooks Brothers, the idea of this statute is that I can demand that Brooks Brothers give me back that information in a portable fashion so I can share it with their competitors, and I can ask them to delete it. So the right of access is an important right. Data subject requests are going to become a real thing in the United States. That was core to the GDPR as well. Right of access. Right of deletion, the so-called right to be forgotten, probably the most interesting, at least to me, to talk about. How, in my world, thinking about privacy, the concept of a right to be forgotten, I think, comes from a policy standpoint. People had a view that when it was time to get a job, you ought to be able to sort of do away with your youthful indiscretions on Facebook and just zap your social media personality. Looking at my daughter who's applying to law schools now, and she's, yes. But what the law does is broadly provide a right of deletion. A lot of exceptions to that rule, but it's going to create some interesting issues. There's then the right of equal treatment. The concept that if you exercise your rights under the law, a company can't treat you differently because you've exercised those rights. Sounds fair? Sounds pretty simple. That equal treatment requirement is probably giving us the most conundrums in terms of people coming up to speed and operationalizing compliance strategies for this new regime. And then the last is the right to opt out. So, big difference between CCPA and GDPR is with GDPR, you need a consumer's consent, affirmative consent, to collect or process their data at all in the first instance. The CCPA, the framers of the CCPA were of the view, and this was something I think that the tech companies negotiated for with McTaggart, was they said, look, you will break the internet if you say we need an affirmative consent to data collection before we even collect it. And so the agreement was, if you disclose everything you're doing, you give consumers the right to opt out of the sale of their information. That's the way this statute is set up. With the exception of children, for whom you need opt-in consent before you collect or sell, before you sell, excuse me. So the kind of deal that was made, if you will, is that the tech community got an agreement that that the ad tech business could essentially continue data collection and web tracking technologies could continue firing on retail websites, so, provided that consumers have the right to opt out. The CCPA contains a very limited private right of action. Again, this is kind of consistent with McTaggart's personality. He wasn't looking to create a big bonanza for plaintiffs' class action lawyers. He was looking to really solve a problem, and so he was persuaded not to include in this statute what is included in many privacy statutes nationwide, which is a private right of action, a broad private right of action with statutory damages. This statute does not contain that. The concept is that the California Attorney General will enforce the law. And it's going to be interesting to see how that works. The California Attorney General is a little bit more ferocious than a typical data protection authority in the EU, probably. They've written regulations. They're just out. They're being commented on. December 6th, I think, is the deadline to submit comments. So the statute is sprawling, 10,000 words, overdrafted. It's not the Securities and Exchange Act of 1933. It is, sort of a group of people got together and wrote a law trying to anticipate everything. So it's hard to read. It's got a lot of internal contradictions. It's got typos. We live in an interesting time. So it'll be great to talk about this today. There's a new ballot initiative that McTaggart has put in play for next year. So there probably will be another mid-year negotiation over statutory amendments that will either take effect or it's hard when you come in last because you end up having to sit right up. So that's the framework, and Christopher.
Sure. That's, thank you very much, Seamus. It's setting us up beautifully. One other little nugget to share with you about the political economy of this act. In California, legislation that is enacted by referendum can only be amended by referendum. The legislature cannot amend it. So it commits, if it had passed, it would commit any further changes to it to go through a different process, a referendum-style political process than a regular legislative one. And we see that we are now in a repeat play game because he has learned his lessons well, shall we say. All right? So we have a high-level overview. The first set of questions is, I'll start drawing you, Lisa, if you don't mind, is that you've also said you're quite busy with your client base, trying to get them ready for what CCPA is going to require. What does it really mean? I mean, what does the CCPA mean for your clients?
So we are working on 87 CCPA compliance projects, and that means, and I can't remember the day countdown, but you guys are probably keeping track of the number of days. But that means that we are vacillating between client moods from frustrated at the failure to respond as quickly as we would like to angry. And that's just where we are right now. And the reason for that is that many of these clients started early. Many of them started really a year and a half ago. And they were just so far ahead of the game, and then the regs came out and changed the name of the game completely. So every document that we drafted, almost every document has to be redrafted. And that had to happen between the time the regs came out in October and January 1, not because the regs are final, they're not, but they are guidance. And they're really a strong view, we think, of how the Attorney General will feel in its enforcement. So we have to consider the regs. We can't ignore them and hold until the final regs come out. So how do we manage compliance? So starting a year and a half ago with clients that were ahead of the game, and there were a lot of them because everybody was very concerned about this. You know, we go from a sectoral regime in the United States to all of a sudden having the first comprehensive privacy law in California. You know, how bizarre that we have one man drafting the law of the land in privacy in the United States. It's really an anomaly, but here we are. And we had, by the way, 4 years leading up to the compliance deadline for the GDPR. The GDPR was negotiated over the course of 4 years. This was done over the course of, a few months at best. So how do we think about this? We had to create sort of a scientific method because otherwise we would go insane. So we start with due diligence. Now, for companies that had to comply with the GDPR, and GDPR is really different. It really is. They're apples and oranges. I would say they're sisters, not twins. Let's put it that way. So for those companies that had to comply with the GDPR, they knew their data flows reasonably well. They knew where their data was located. But for many companies, many of our clients, like gigantic US retailers that don't operate in Europe, they didn't have any earthly idea what their data flows looked like. So we needed to first understand data flows reasonably. We're not going to ever pretend that we know the data flows very, very well. No company does. Janie accepted. So understand your data, and then once that happens, we needed to comply with what Seamus has so artfully put on the table, which is changing privacy notices. Now we have, because of the regs, we now understand there needs to be a notice at the point of collection as well as revisions to privacy policies, so 2 different types of notices, including in-store signage, which we're now going to see in California, so that's going to be fun. We needed to make sure that we are accounting for the rights to access one's data, and the right to access one's data, the right to delete one's data, and the right to opt out of sale. A response to an access request is about the ugliest thing you've ever seen, because you have to provide the category of personal. You have to provide the data itself if the requester passes a verification test. You have to provide the actual pieces of information. And it drives me crazy, by the way, that we're using pieces of information, not data elements, which is used in every other data protection law around the world, 130 of them. But the terms differ, and that's, really kind of annoying for those of us who practice all over the globe. In any case, we need to make sure we understand where the data is so that we can respond to an access request, the specific pieces of information, the sources of information tied to each category, the third-party categories of third parties with whom we're sharing the information for a business purpose, for a sale, the purposes for using the information. So all of this needs to be consolidated in response to an access request. Second, the deletion right needs to be managed. And by the way, this is all in 45 days. You have to respond within 45 days. You can get a 45-day extension, but that's it. And you have to respond within 10 days now pursuant to the, 10 days, yeah, pursuant to the regs, just to acknowledge the response. So the deletion request is actually enormously complicated because for the most part, companies do not actually have to delete data. There are 9 exceptions, and they cover just about everything other than marketing and personalization. So that's where, it sort of ends up. And then the opt-out of sale right, which is different from anything we've ever seen anywhere in the world, and we're now going to have a clear and conspicuous button in our footers, so everybody's going to have a little button that's clear and conspicuous in the footer that it's going to say either the words, do not sell my personal information, or do not sell my info. That's what the AG has said the words need to say. So now, creating the back-end process for that in the incredibly complex ad tech ecosystem, if somebody clicks on the do not sell my info button, making sure that that message is conveyed to any party that is not a straight-on service provider to the entity is really, really challenging. And then more to do. You need to change your vendor agreements because they have to have specific language in them in order for vendors to be considered service providers under the law, which is a benefit to the company because then you don't have to address them in your privacy policy. You don't have to address them in response to access requests. And finally, there's a whole host, well, not so finally, training, pretty significant. You have to, that's mandatory. And then there's a host of other documents like a log of consumer requests. You need to have financial incentives. If you have a loyalty program, you need to have a document that says, here are the details of my loyalty program and I'm opting into the loyalty program. So a financial incentives document along with the policy that goes with it. There's a whole host of ancillary documents that are in addition to the sort of consumer-facing documents that we're drafting. I'll stop there.
That's wonderful. I do want to reiterate our thanks to Meredith for conceiving of suggesting this as an idea, and to both Aiken Gump, Strasshauer and Feld, and to Andrews, Hunt and Andrews and Kurth for supporting this event. And I think that it couldn't happen without them. And I also realize I'm a very bad privacy professor because I should disclose, as you probably all know from the fact that we have a little camera sitting right there, that this is being recorded. And I should disclose that at the beginning. I apologize. And I don't think there's a private cause of action under anything particular in Pennsylvania law. You signed.
We signed.
But just to disclose, and there's all these other things to do as well. I'm sorry? Okay, anyway. But more importantly, it's interesting, both Seamus and you and Lisa have portrayed the impact of this on companies one way. I'd like to bring Janie in, because in our phone call, you had a somewhat different perspective. And I have to admit, by the way, I admire in your bio, you have a number of, accolades as best under 40. I think best is great. I think it's the under 40 that I'm really admiring.
Just to correct the record, no longer under 40. Once, like everyone in this room, right? Once was under 40.
Please.
So yeah, I have to say that I'm not part of the client base that's freaking out. I guess I just, I try to remain calm in every situation, but I think it's primarily because our business, we have the luxury of being primarily a B2B business. We're not consumer facing. We're also, our company has very strong European roots, so about half of our company came from divisions of Technicolor, the French company of movie fame. So we went through the whole GDPR exercise, and I think that was probably much more of a learning experience for us. So compared to that, I think at least my team they're not freaking out quite as much. And also, just being in-house, right, we have to be practical and pragmatic, and just as general counsel, I've always approached basically all of compliance, right? We don't have infinite resources or bandwidth or personnel, and I always want to make sure that our response is proportionate to our risk. So given our business model, given, our relative, exposure to other companies, because it is in the ether, everyone is, ginned up about this, including my board. So, as with cybersecurity and other hot topics, I always have to reset them because they do sit on boards of the high-tech companies that are social media companies primarily, and they'll go to those meetings and they'll get all worked up, and then they'll come to our meeting, and I have to kind of, reset their expectations. So I think all that being said, obviously we plan to comply, right? But it's just not the same gargantuan effort, psychological, physical, that other companies, most other companies, all of your clients, it sounds like, are undertaking. And, at the risk of sounding smug, I just remember Tim Cook giving an interview. This was probably like at least 3 to 5 years ago, where he sought to, and, I've seen companies who have embraced this, right? Like who have publicly, embraced the concept that privacy is a value that they cherish, right? And they actually are proud to build their business models around respecting privacy. And Tim Cook, I think, is like the exemplar of this, right? He's given interviews where he, very smugly distinguishes Apple from the Facebooks and the Googles of the world. He was like, look, way back when we built our company, we decided that we were not going to profit off of selling other people's information, and that's why, Apple is not faced with the congressional investigations and being hauled, before Congress to answer for their sins. And, and here I'm not speaking on behalf of my company, but just as a, individual observer, I do think, yes, it's a lot to comply with, there's a lot to grapple with, but I would also challenge us to view it as an opportunity if we as a society value privacy and, do agree that it's an inalienable right of each and every one of us, then we should rise to the challenge. If we can, invent technological solutions to deliver information to us wherever we are, in whatever form we choose, we should be able to invent the solutions that allow us to also respect privacy while we do that. And, and I would just say it's merely an issue of priorities, right? It's whether we value, finding solutions to this as much as we value making money off of the information that we get.
Can I quibble with that?
Of course. I would be disappointed if someone didn't start this, so please.
So quibbling not with the importance of privacy, but priorities. So Tim Cook, it's very easy for Tim Cook because he makes hardware. Data is the lifeblood of the internet, and it is what makes the internet free. If we don't have data, then we need a different model for the internet. So this has the potential, if we take it to its sort of worst case scenario, of breaking the internet as we know it. And then we go to what, a paid utilities sort of model, which could be discriminatory against people who can't pay the monthly fee to have Google search, et cetera, et cetera. So I think this is a really interesting discussion that we're going to be having over the course of the next 5 years. And there are plenty of people, and in fact, the New York Times, yesterday, the magazine, and I haven't read the article yet, says something like, is the internet broken? And for months now, I've been thinking, yeah, the model that we based the internet on was not right. And we needed a different model, but how did we know? We had no earthly idea. So this is going to be a very interesting discussion, and I've been having a lot of discussions with very, very big companies, because smaller companies don't have the luxury of doing this, but very big companies around data ethics and creating data frameworks so that you have like a 10-point ethical framework that's an overlay to every new initiative, every new technology that you develop, and that will be the lens through which we look at just about everything. So we are going to be having a very big discussion on data ethics, and this is just one of the many new laws that's into that discussion.
So,
So just,
please, go ahead. No,
not to
Please.
be overly antagonistic, but so there was just a book published, I think it's called Do No Evil, right, by a reporter, and she goes back and reads, right, obviously the title is taken from Google's original manifesto, right, when they went public, and they said, we don't need a traditional mission statement, you know, we're good, we just need these 3 words to live by, do no evil. And she went back and read some of Larry Page's, you know, the founders' first writings about their business. And she actually did find, it was kind of like a footnote, it was tucked away at the end, but they did identify this very risk. They did envision a future in which, if their business model was successful, that they would have to grapple with this issue. So, you know, I agree. No one could have predicted, you know, to the full extent kind of the situation we find ourselves in now, but Google's own founders, right? Like, if you go back and read what they wrote, they were like, oh, you know, we could have a monster on our hands if, you know, everything is as successful as we hope it is.
it's even worse than that. Larry Page and Sergey Brin, when they invented the algorithm, said they would never do advertising. You know, and it's an interesting, I don't mean to hold, things change. I'd like to bring Lauren in, and by the way, but on this question about the business model, there's a bunch of writing about this, but my favorite thing that I like to do when we teach privacy together is I ask them how many of them use a Google project. You know, whether it's Gmail or Search or Google Docs, the answer is all of them. And everyone says this, people just don't know. I asked them at the end, how many of them have given it up? And the answer is, I think we've never had more than 2.
Yeah, that's not many.
And I asked them why, and they say it works beautifully and the price is right. And so it's an interest, I mean, I think you're right, Lisa. It's gonna be hard to wean people off of this, whether we should have gotten here or not. The reality is there is strong consumer support and desire for this particular form of financing, and we see it in old broadcast television, some newspapers to today. It's really quite interesting. Now, Lauren, I think you have a very interesting take on what CCPA is going to mean from your perspective, and particularly from a compliance perspective.
Sure. I love this discussion already. So I'll start by saying that I'm the Chief Privacy Officer of Penn Medicine, which means 2 really important things for this discussion. One is that I work for not-for-profit, and the other is that I work for a HIPAA-regulated entity. So both of those are incredibly important when you look at the CCPA language, because there's basically an exemption. It doesn't mean we won't have some impacts. We will have some impacts, but I think not to the degree of a lot of your clients. But I've been in privacy for a long time, and I'm still watching this with great interest because I'm trying to understand, why is this so dramatic, right? Why is this so transformative? And a few things have come to mind for me. One is, I think Lisa started to talk about this as well. Prior to this, our privacy landscape was vertical, right? So we had certain industries that were regulated and certain that weren't. So healthcare is regulated, financial services, education, video rentals, drivers, DMVs, this kind of smattering of industries that were regulated, and they were regulated in roughly the same ways according to principles that we kind of got used to. Things like you generally describe in a notice what you're doing with data, not with the particulars that you're seeing with CCPA. Things like certain uses are just going to be beyond consumer control or user control. So for example, in HIPAA, we get to use patient data to treat you, and you don't get to opt out of that, right? And that's because that's core to what's happening, and there was this basic agreement after deliberation that that's the way the answer ought to be. So we had this landscape of privacy that we got used to. The regulated industries got pretty good at it, made a lot of investments, knew the rules, and mostly it didn't break us, okay? It caused some real cultural shifts, and I think those have been incredibly positive. I want to talk about them a little bit, but it mostly didn't break us. So we had this sort of, vertical silos landscape. You were either in or you were out. Along comes CCPA and just cuts a big horizontal line through everything and says now everybody is going to be regulated. So companies, the ones who were out before, it's actually funny, in our class when we'd start, first day, what's on your mind? What are the big privacy problems of the day? Social media, okay? App developers, online retailers. All of those industries were, for the most part, you can quibble with the good lawyers around here will tell me I've oversimplified, but for the most part, we're out, okay, of regulation. They'd make their statements, they had to live by the statements, and they were out. But the ones who we thought were the most problematic sectors were not the regulated sectors. So now we have everybody in, and suddenly people need to understand what the requirements are, and they need to build compliance programs that they hadn't built before. So for healthcare to get another couple of requirements layered on us, I'm not welcoming it or asking for it, but if it happened, there's a structure in place, right? We know roughly what these principles are. We've got engaged people throughout the organization how to make it work. So that's one big difference, is the horizontal covering everything. The other is that these requirements are new, and this was mentioned before too. The right to deletion didn't exist except in credit reporting, okay? So this is like way back, but the 3 credit bureaus, the Equifax, Experian, and TransUnion, thank you, they've always had to provide a right to delete. In fact, they had to automatically delete negative credit entries that were more than 7 years old. And the idea was you had the right to rehabilitate yourself. You could do a bad job on paying your debts, you could have bad financial straits, and then you turn it around, and you ought to be able to create a new life for yourself. And so that right existed there so that you didn't lose jobs and mortgages and homes because of things in your pretty far away past. But that was it. We never had that anywhere else. And now we've got this right to deletion, not over data that could do harm to you if it's wrong, but right, or even if it's right, but right to deletion because that's your right, right? That becomes a consumer right. And that's just really dramatic. That's a very different policy approach to regulating privacy. So that's a fair amount to take in. And unlike some of these other privacy rules, it's just fast, right? It was developed fast, and we need to comply with it fast, and that's really, really hard to do. So I think these compliance programs, again, that usually take time to grow, right? Because you need policy development, you need training, you need risk assessments, and an infrastructure, and reporting line, and investigations, and all of these functions. That has to get developed incredibly fast for industries that haven't done it to date. So that's the bad news, if you want to go good or bad, is that this is a lot of change, very different in philosophy and happening really fast. The good news is I think companies are better when they go through exercises like this. I think they know themselves better. The whole where is your data and what do you do is not always a question answered accurately by companies that don't go through an exercise like this. So, for example, if you have, I always think about this, if there's a company with one database, it's a customer database, and then a second database is the employee database, and they have to comply with the laws like this, I'm gonna say, deal with it, right? That's not so bad. You know where your data is, you know what you use it for, write the notice, give them the rights, and that's done. Most companies don't operate that way. Most of them have many, many business units, countries, product lines, innovation shops whose very jobs are to push the envelope and use data and develop products in different ways. And mostly, the mothership may not know everything that's going on throughout the world when you don't have a requirement to do so for a regulation like this. So I'm going to just take the rather controversial position and say that eventually we'll be better off for this. Companies will run themselves better because they'll find out about programs going on that they don't want to go on, right? What's going on in, wherever, Bangladesh? Wait, we don't do that. That's inconsistent with our mission or our values. So I think that companies will get better, and I think cultures will change, and I think privacy will be advanced because we're going to all get better at understanding what it means. We're going to get better at understanding that we have some rights. The trick is to get all those positives in a way that doesn't break the good things, in a way that doesn't solve the wrong problems, impose too many costs. And this is why regulation's hard, why policymaking is hard, why some geeks like me think it's really fun and important. But you need the time to think it through. And I don't think there was enough time to think through and get that balance just right.
Yeah, I would echo that because I think when we went through GDPR, we are now a better company for that exercise. We did tabletops, we had to work very closely with our IT department. And I remember, right, all of the usual complaints. It was like, we wanted to put in the language requiring all of our vendors, we're trying to shift as much risk as possible. And, we didn't even get to the vendors yet, and my own IT department was telling me they will never agree to that. How can you even ask them? And I was like, really? I was like, well, let's ask instead of negotiating against ourselves. And what we found was that the reputable, upstanding, good vendors stepped right up and they understood. They said, of course, we will do this. And the vendors that you should actually, like, we actually had, probably had many other reasons to, like, really question whether we wanted to bring them on in the first place. They were the ones who pushed back. Like, they were the ones who weren't even aware, had no clue, had, really doubted their ability to do this. And we were like, well, you know what? Like, we actually don't even trust you to do the work, much less this tiny, compliance provision. So, and then, another example is that, we had to talk to each, function and just make sure, like, where's your data? Who's in charge? What do you do with it? And it came to our attention through this exercise that our marketing department, actually on their own, they thought they were being really creative. Their budget had just got cut and they had this great idea to fill the gap by selling the emails, the email addresses that they had collected over the years. And we're like, yeah, no, not only can you not do that under GDPR, because when you collected the information, you didn't tell people you had these plans, but also I literally had to have this, conversation where I was like, you understand our business, right? Like, we are not a marketing company. We are a tech company. This is our core mission has nothing to do with monetizing email addresses that you collect from people who visit our website. This is a distraction from our core business. You should be focused on our core business. So it was just this revelatory, like, oh my God, would I have found out about this if we hadn't asked because of GDPR? That our marketing department was kind of like off thinking, oh, this is a good idea. This is something we should be doing. So I completely agree. When we first were faced with GDPR, it was all complaints. It was all, oh my God, Europeans are crazy. What are we, And by the end, everybody was on board. Everybody was like, you know what? Like, I'm glad we know where all of our data is stored. I'm glad I can go to one person or a data protection officer and he can tell me exactly what to do when. It makes me feel so much better about our business as a whole.
So I'm going to violently agree. So we could not be more out of step with the rest of the world. Every first world country, other than the United States, has a data protection law. Many second world countries and many, many third world countries have comprehensive data protection laws. We are in a very difficult position at this point in time where we have over a dozen federal privacy laws, and Lauren went through some of them, as silly as the Video Privacy Protection Act, which was enacted in the wake of Judge Bork's nomination because the Dems were trying to dig up dirt, and the Republicans weren't happy about digging up video rental records as dirt, and then they passed, in the wake of that nomination, the Video Privacy Protection Act.
So quaint now.
So quaint, but has come back in some lawsuits. We have hundreds, literally hundreds of state laws, and the irony of all of this is that we passed the very first privacy law in this country in 1974. Test. What happened in 1974? Exactly. So Watergate happened, and we passed the Privacy Act of 1974, which applies still to the federal government, and most of the, all of the international instruments that embed privacy principles, where, by the way, privacy is a fundamental human right, pick up on the concepts that we put in that very first privacy law. So we came from being first to being absolutely last, dead last behind many, many third world countries. So it is high time for this sort of a law. It is not, in my view, ideal for a state to be leading the country by the nose on this. It would be better if we could get some agreement on something by our current Congress. And I have heard the very same thing that Seamus has, which is I spoke to a high-level person in Congress last week, well nigh too impossible at this point. And it might have been possible 6 months ago, 3 months ago, getting more and more impossible as time goes by. And now we're looking at Texas possibly passing this sort of a law, Massachusetts, They had a hearing on it, on their law with an extended private right of action that looks just like the CCPA. The New York AG we know is gearing up. There are other states, Nebraska as well. So there are other states as well coming down the pike. There's no question about it. So we're going to have this cacophony of laws in the United States. And I would bet you that some states are going to say, you know what? We're going to get in line with the international standard where, of course, the beacon right now is the GDPR. We're not going to follow the CCPA. So we're going to have this fragmented approach in the United States, which is going to make it really tough for folks like you to comply.
Yeah, I just want to add a little bit to that comment, because that really troubles me, right? The creation of new laws in various states that are all a little bit different. We have it today in this area of breach notification, and California led the way there as well. In 2003, California said, listen, when companies breach certain types of data of California residents, they're going to be obligated by law to tell them about it. And that was transformative as well. So what followed then is 49 states. So we're now up to 50 states. Every single state has a breach notification law. However, they have different triggers. They have different time frames. They have different content requirements in the notices. They have different requirements as to whether you tell an attorney general, or whether you tell a secretary of state, whether you email them, whether you write them a letter, okay? Now, that existence of very inefficient regulation in this single area that's pretty straightforward, actually, of breach notification is aggravating, I will say, as somebody who's been through having to say, okay, we had a problem and we had 3 people from Virginia and 2 people from New Jersey, so we have to do different things because they have different laws. But you can live with it, right? That's just like extra work and an extra letter and an extra email. It's not going to break what we do. Having different laws regulating where data can go and where it can't go, if you have 50 laws with different rules about the fundamental running of a business, because data is the lifeblood of not just commercial entities, not just the sort of the tech sector, but certainly everything, healthcare, financial, everything. If we end up with incoherence because we have too many state laws going in different directions, that's going to be very, very broken. So I mean, I'm very idealistic, and I think from a policy perspective, not a politics perspective. It's just naive, I guess. But I think this is really one of the strongest cases to have a uniform way to do this, because if we end up with diverging standards 50 times over, we got a real problem.
I do want to acknowledge, though, I agree, very dysfunctional right now in DC. So I run government affairs and legal affairs for my company, and just today, though, this quartet of Democratic senators representing, I think, 4 different committees in the Senate did put out, oh, sorry.
You're off.
That's weird. Thanks. Did put out a statement. It really was a call to action laying out what they, consider to be core fundamental privacy principles. So I think there are certain office holders who are trying to still move the ball along, even though I agree with you, the long-term, the prospects for actual legislation remain slim. But I think something has changed, like in terms of people's willingness to at least acknowledge that there's an issue, even if they don't have right now the political capital to get it done.
Well, I have to give, Lauren a lot of credit for educating me about something, which is, Lauren always says, you look at a law like this, reading it is the easy part. Understanding that, oddly enough, in compliance regimes, unless you document it, it didn't happen. And so it's not just the requirements, it's the implications of the physical documentation of all these different state regimes, the training you have to give your people, the verification you have to do, and the execution is sort of the hidden cost. You can look at the surface of the rules. When you start to think about what this means for organizations, it requires them to employ a whole bunch of new people and for good purpose. But there's better ways to do this and other ways that don't. And I'm always reminded of, to go to a slightly different context, in terms of our national securities laws for surveillance, there's something called the President's Civil Liberties Oversight Board, or PCLOB. And they periodically review statutes, and in the most recent review, they said, keep this one, it's actually helping preserve, say, fight terrorism. This one sounds good in principle, but in practice wasn't really making much of a difference. And so this very pragmatic idea of not just doing things because for their own sake, but doing it with an idea of this sort of cost-benefit analysis and the effectiveness is an essential part of what Lauren's taught me you have to think about from a compliance standpoint, because you don't want a compliance regime that exists for its own sake. And unfortunately, there's a couple of them that we have that seem to be that.
There's a paper that was put out by one of the California agencies. The cost for initial compliance with the CCPA is $55 billion, initial compliance. The total compliance cost, I just wrote these numbers as I was running out the door today, $467 million to $16 billion over the course of the next decade. For continuing compliance costs after that. For companies with under 20 employees, they're anticipating costs of $50,000. For companies with over 500 employees, the average cost in initial compliance costs is $2 million. So this is a pretty penny.
So let's talk about this for a minute. Under 20, you mentioned. The cutoff for CCP is 25.
Yeah.
Why are these companies at 20 incurring all these costs?
I wouldn't. I don't know the answer to that question.
Is it abundance of caution, or?
Yeah, I don't.
So they may not have a
actually don't know
compliance
whether
lawyer to tell them that they're
I don't know
not,
why
they're not bound by this
measured
law.
that.
No joke.
Now, bear in mind, but there are 3 eligibility criteria. One is not
They
just
need
size.
to pay $50,000 to get that answer, that you don't know. Yeah.
I mean, what should scare everyone is that the Attorney General's estimate of the cost is, I don't know if you heard, Lisa, between 467 million and 66 billion. That should be on Saturday Night Live, right? That's honestly what they said. So
Are you
they
suggesting that
they
range?
could have said, we have no idea, but they chose 467 to 66 billion.
And this is, the $55 billion number is 1.8 of California's gross state, 1.8% of California's gross state.
And is this based on private lawsuits also?
No,
Because that's
no. This
that's
is
just
compliance,
compliance costs.
straight on compliance
Okay.
costs. Yeah.
Because that's another major
That's
difference,
coming.
right, with the CCPA, is that there is a private right of action for some violations. And that's another policy question, right, of what problem are you trying to solve? I mean, if you're trying to have companies behave better, you can do that without a private right of action. You can do that with strong enforcement from attorneys general, from different federal agencies, and write the rules and say you're in big trouble if you don't follow them. And that happens with a number of privacy regimes. But if you're trying to solve another problem of people who are actually harmed, then you can give them a private right of action, although I'm not sure there's a harm connection to this particular private right. There's a risk, but there's not a clear demonstrated harm to this private right of action, but that's going to result in cost too. You know, all of these are decisions that I think can be responsibly made after discussion of the pros and cons and the trade-offs that come with all of these requirements and all of these provisions. So again, I come from, my background prior to this is I was at OMB working on the development of the HIPAA privacy regs with HHS and many of us. And so my background is I saw notice and comment rulemaking in effect where 53,000 people wrote comments, and there were boxes in the HHS war room, and this one said, this is about people worried about disclosures to family and friends, and this is about people worried about disclosures to law enforcement, and this one's worried about disclosures for research. And what are we going to do? And there was this big policy deliberation for, I don't remember, a year and a half. You need, when you're talking about anything as important as data, and the cost is staggering as what we're hearing here, I think you got to take a step back and have the real live policy debate and figure out what trade-offs we really want to live with, instead of just saying here it's someone else's problem regardless of the cost.
Just to give a sense of the private right of action cost, there are 2 statutory penalties that are in the law right now. For a violation of the privacy provisions, you could be fined up to $7,500 per consumer, but that's only AG, right? So these, of course, will all be negotiated. For a data breach that results from you not having reasonable safeguards in place, and by the way, there's 0 about security in the CCPA, 0, but for this liability provision that allows for the private right of action. So to the extent you don't have reasonable security in place and you have a data breach and you didn't cure within 30 days of you being notified, which is mystifying. How one could cure a data breach that has already happened is mystifying. In any case, the top penalty for willful violation is $750 per consumer. Now, to put some perspective around that, we have been settling, we just handled 42 Yahoo consumer class action lawsuits and many, many other data breach lawsuits. And we've been settling these somewhere between 35 cents on the dollar to about $1.30 maximum per consumer. Now we're going to have $750 per consumer. So think about the staggering potential for that kind of a penalty.
So are there particular chestnuts in the CCPA that people don't know about, that the wise council are focusing on, that a trap for the unwary, perhaps?
You know, I think you would have to look at the anti-discrimination rule and really think about how it works in practice. So when you think about your business and now you have to comply with a do not sell request, how many of your vendors are providing services that enhance that consumer's experience, and now those things are not going to be available to the consumer? So something as simple as autofill is part of my Google Analytics relationship. If my transfer of data to Google is considered a sale, which it clearly would be under the statute for almost anyone, what do I do about the fact that that consumer's experience on the internet is now going to be hampered? You know, they're not going to get the ad tech driven advertising that they're used to that's relevant to them. All of a sudden they're going to see ads for baby food, you know, when that's not something they're interested in. People are really struggling with how to reorganize their business so that the consumers who opt out of the sale of information are not prejudiced. Second, you have large sectors that are really struggling with the idea of the definition of sale under the statute. So the definition of sale is so broad and captures so many data transfers that you have at the board level companies really struggling with the idea of telling their customers that they sell information. They don't believe they do sell information, but under the definition of the statute, they do. So it's a really difficult problem. I mean, those are the two things that come to mind that are really causing angst as we come, you know, we're sort of approaching days before the effective date of this thing. As outside lawyers, we get the hardest questions, right? I mean, there's not huge budgets for dealing with this, even at a company like InterDigital. And so you've got heroic in-house lawyers, I mean, just killing themselves, dealing with their IT people and trying to put together something of a compliance strategy for this monster. And it's sort of come time where now all the questions are popping out to us. So those are the most puzzling, I think.
Yeah, I completely agree with that. And, it's an interesting, I think, view over time where the questions a year ago were actually really easy. And now the questions are incredibly hard because in-house folks are very sophisticated now, and they've been struggling with this for a year. A couple of other items to mention that really stem from the regs. I think that is do not sell is just a huge quandary. Who are we really selling to based on the definition? And just to put some color around that, a sale is any kind of a transfer or making available of personal information for monetary or other valuable consideration. And it's the other valuable consideration piece that is tying everybody up in knots. And everybody agrees now that the ad tech ecosystem is really all about other valuable consideration, transferring back and forth. So there's some interesting points in the regs that I'll just mention. So first of all, there's a concept of valuing data. You're required to indicate the value of data if you are offering a financial incentive, a loyalty program, right? So you're required to actually put into a document the value of your data. So if you say, I think your data is worth $5, and then Walmart values your data at $45, that's kind of problematic. But even more problematic than that is you've now given plaintiff's counsel the number to put on a data breach litigation, right? You've told them exactly what the data is worth. So that's problematic. And these all might change, by the way. This is all in the draft regs, and so, certainly subject to shifting. There's also a really horrible 90-day look back on do not sell. So if I click on the do not sell button, then the company, the publisher, the website, needs to tell all of the entities to whom the publisher is disclosing data for a sale that they need to stop selling data, and then they need to look back 90 days to all of the entities to whom they sold data in the past 90 days and go back and tell those companies, you can't sell this person's data. I mean, everybody's sort of throwing up their hands like, no earthly idea how to do that. On the good news front, the verification procedures got much, much more stringent than at least I thought they were supposed to be in the law itself. And that is really good news. I've been very worried, frankly, about the requirement to disclose specific pieces of information to individuals. I've been worried about it from a physical safety perspective, because if Lauren decides to impersonate Lisa and asks...
Could be fun.
Could be fun. Could be interesting. And asks
Good travel, I know.
Rite Aid for my information. That would be interesting, right, to see that information. But here's a real example that actually I was speaking to a pharmacy chain about. Wife asks for the husband's specific pieces of information and finds that there was a transaction done last month for condoms. Wife is on the pill, right? So that's sort of an interesting, and that's not even, the worst of the examples that you can come up with. So the regs made it very clear that you have to run through a pretty darn onerous verification series of steps before you can actually disclose specific pieces of information, including requiring from the requester a declaration under penalty of perjury that I am who I say I am. So that's a very good thing, and I think that's a real positive change that the regs have brought that I certainly was not expecting.
So I'm about to open it up to questions from the audience because I imagine that there might be some in an issue like this. But before we did that, there's one other topic I wanted to talk about, which is, so what comes next in terms of not just implementation, but we've talked briefly about federal regulation, others. I mean, what do you see coming next? Because we've been hearing a lot about things coming and we're not seeing them come.
The one thing we are going to see come is the CPREA, the ballot initiative number 2.
Ballot initiative number 2.
So
Keep Play Game.
we're going to see that, and Alastair McTaggart has said he has no interest in tangling with the legislature anymore. He's done with lobbying. He's done with lobbying interests, and he's going to push through his ballot initiative, which is, again, one man shaping privacy law in the United States without a legislative process and comment. There is a small comment period, but it's not what it ought to be in this kind of a process.
So,
If you don't mind, let me embarrass my partner, Ed, who's, I know, in the mix and in the throes of things happening in Washington. Any hope?
Well, I'm going to say, as you guys talked about, there are complicated issues that Congress is struggling with. There's not a McTaggart in the U.S. Congress that's forcing them to perhaps act. They're really struggling about 3 things. One, enforcement. Should it be a private right of action? Should it be the state attorney generals? Should there be some combination of that? Should the Federal Trade Commission really step up and get more enforcement? The other thing I'd say is preemption of state laws. Should it be a national standard? Would it preempt California's laws? Would it preempt all the 50 state laws? Folks from California, naturally legislators, including Speaker Nancy Pelosi, may have issues with preempting California's law. But if the national standard becomes, the other thing is the scope of the national standards, the third thing we're looking at, and if it becomes California's law, that may be kind of an out for Congress in that sense. And just last week, Microsoft announced they're going to apply the CCPA nationwide. So that may be a model. We have other clients that are looking at that perhaps, and perhaps that may allow Congress to better legislate. But it's very complicated, and I think Congress doesn't want to make some mistakes that they think California did by rushing it. It takes a long time. Now the other states are acting. So actually the creation of a patchwork may force Congress to act, but it won't be down the road.
But there's been a bipartisan group of senators who keep saying they're going to drop legislation. They keep
Yes.
month after month. And one of them is Cory Booker, who I understand has some other things keeping him busy these days. But, you know, it's one of these things we keep getting legitimately, I think they mean it when they say it. They think they're almost done, but we keep not getting the draft bill.
We've not gotten it yet. We're still waiting, right? It's been about 9 months since they thought it would be next week.
And it's hard to start that conversation until you have something to converse about.
Very much so.
So also the legislation varies in terms of what problems it's trying to solve, right? And so some proposals are give more money to the FTC for enforcement, and some proposals are about breach notification, some proposals are about do not sell. And so some are going to be easier to pass than others. I'm not sure any of it is going to actually get passed. But if it did, it's not clear it's going to occupy the exact same space that CCPA is occupying now. And I also just want to add, in terms of what comes next, it's going to be a different answer. It's not about legislation, but what I hope comes next is better data governance infrastructure at organizations, because I think, let's say we end up in some good place in terms of the policy and requirements out of California and other states and federally. I think what we're learning is that we should be seeing this as a wake-up call to the fact that we need better structures in place in all of these companies that have data, so that the sort of medium-level decisions get made by the right kinds of people, and the riskier, more complicated decisions get elevated to people who know some of the intricacies of these laws better. I do think data governance is getting hotter on the map, and I think that's a good thing.
Questions? I'll start here.
I'd like to ask the jurisdictional question directly. This is the California law. Everyone's reacting to it as if it were a national law. And maybe the answer is obvious. The big tech companies are in California. California's a huge number of people. But would you be reacting in the same way if the state that passed this were, say, Wyoming or Alaska?
I mean, so it's a great question. And one thing to understand is that this is really a breathtaking assertion of jurisdiction in the statute. So what it says is, if you do any business with any Californian's data, and you have 25 million in revenue, not sourced from California, but from anywhere. So this is about touching California, the 5th largest economy in the world, right? So we have clients that have come to us. Part of the reason the last couple of weeks has become so sort of frenzied is you've got companies who are, say, regional companies from this region, who are just really coming to realize that because they touch 30 or 40 Californians a year, under the test in this statute, they've got to add 3,000 words to their privacy policy. So I think this will be challenged in the courts. It's one of many things in this statute that will be challenged in the courts. I don't know where it will all come out, but all you need to do is touch California. And if you meet the other the standards for being a business under the statute, you've got a major compliance job on your hands, even though California may be a very small part of what you touch. Interestingly also, if you read the statute literally, any company that is within your corporate family. So if I'm a retailer and I have a little belt manufacturer in Texas that's selling only in Texas, the fact that that Texas company is under shared ownership with an entity that's otherwise regulated under the statute, that business is regulated as well. Again, a ridiculous assertion of jurisdiction, probably won't hold. The courts will ultimately have to figure this out, but it's breathtaking.
Yeah, I think it's a great question, because contrast this with, for example, another area in which California has recently taken steps to be a pioneer is requiring a certain number of women to be on corporate boards, right? So there's a relatively new law, and it's got a tiered approach. For smaller boards, by X date you have to have at least one woman, for bigger boards 2, and then 3. But the way they define whether you're a company that's subject to the law is if you're a California corporation, which means you're either incorporated or you're headquartered in California. So we're a tech company, but we're actually incorporated in Pennsylvania and headquartered in Delaware. So we are not subject to the law, but we have 2 women on our board. We're always looking to increase that number, right? So we certainly took note of it. And certainly, at some point, we, even if they don't expand the reach of the law, we fully expect other states, New York, to follow suit. And so, I think California enjoys this unique position of being such a large economy. Again, going back to government affairs, we actually have a strategy sometimes if we feel like DC is deadlocked. We actually do contemplate, could we actually initiate and spur legislation at the state level and have that spur federal legislation? And California is always the first place to look because it's one of the few states that has this power.
Well, I'm going to introduce the person who's going to ask the next question, just because of who he is and what he's meant to this school. It's Colin Diver, who was previously dean of this law school. If you want to see in the hallways downstairs, his portrait hangs on the wall in all its distinction. Left to become president of Reed College, among other things, and is a return to grace us as a professor once again. So thank you, Colin.
Thanks, Rick. So you talked a lot about the costs of the California legislation, which, whether it's between 400 million and 55 billion, it's going to be a lot, big number. But you didn't talk about the benefits. And I'm thinking, as a consumer, do you think that more than maybe 0.1% of consumers are going to exercise any of the rights under the California law?
You know, it's a really great question, and if you talk to the lawyers that experience this in the GDPR world, it really isn't many. The data subject requests and the deletion requests that come in are marginal. This law contemplates that sort of the creation of a third-party industry where agents could go out and create apps for consumers to help them make deletion requests. So when you put this in the American economy, it's going to be incredibly interesting to see what happens. You know, one of the exposures that we talk about with clients is that one of the things in California is you've got a really active and creative plaintiff's class action bar. And so regardless of the lack of a private right of action, I think they will monetize this law in some way. And one of the things they'll do is use the law as a vehicle to draw information out of companies in employment litigation and other related kinds of litigation. But look, let me say this. I do think, it gets back to what Lauren said, companies are going to develop a set of muscles now under this law around consumer data. They're going to data map. They're going to find out where their data is. And so I think this obviously could have been done better. I think this is going to be incredibly disruptive. I think it's fundamentally ill-advised in so many ways. But I do think it's going to wake up companies and ultimately, hopefully, thoughtful people at the FTC or somewhere will come up with a workable set of rules that we'll all look back. I don't know that we'll laugh, but there is going to be that positive effect. So
I do think the opt-out of sale button is a very concrete example of something that probably 80% of the people who know they can click on this button will do so. Why wouldn't you look at this button that says, "Do not sell my personal information," and it might be preceded with the word California : why wouldn't you click on that? So I think there's going to be a huge uptake with respect to do not sell. And then I think in the first few months, we'll see a very significant uptake in access requests and deletion requests, and that will die down because we've seen that for GDPR. Now, just to note for GDPR, the Data Protection Directive in Europe, which had the very same rights, but for a couple, was in place since 1995. So Europeans were very familiar with their rights and have been exercising them since 1995. So this was really, the GDPR was just a continuation. This is the first time that we're seeing this in this country. So I think there is going to be a real uptick. I do think it'll sort of, we'll reach a stasis after a little while. But then we won't, because another state will enact, and another state will enact, and another state will enact. And to just also note that there is a law that passed in Nevada that became effective October 1 that has a pure opt-out of sale obligation. But sale is defined as a transfer for monetary compensation alone. So it's the traditional definition. And nobody's really blinked much of an eye over that law. We also do have two new other laws that I'll note, that because I think they sort of go hand in hand, and those are data broker registration laws in Vermont and now California. So we are now going to see lists of who's a data broker, who's actually trading data, which is going to be very interesting. And of course, plaintiffs' counsel are going to be all over this.
I just want to thank the panel. It's been a really great discussion. My question is, one of the things the panel mentioned was that the bunch of different laws. We have 50 different laws from 50 different states. If you look at the proposals that are being generated in Congress, they're all different. What do you think it is about privacy as a subject matter that makes it so hard for everybody to sort of come to agreement on what it is we should be regulating and what we should be doing?
Well, it's a very interesting area because this is almost where the right and the left sort of come together. Remember Dick Armey joined the ACLU years ago just to do privacy, which was just the most bizarre union. But I do think there's a real possibility for this to be bipartisan. This is one issue that can be. And then there are issues that, as you said, that separate us, separate the right from the left on private right of action and preemption. And those are issues that hopefully are not irreconcilable, but seem to be at this point in time.
One of the things you see, Vernon, in the law, and this is the example I always think of, is this idea of the right to be forgotten, right? If you think in terms of just pure privacy, if I make a plan to overthrow the government and I put it in my study, in my drawer of my desk, that's a private paper, right? If I take that paper to my book club and share it with everyone, the idea that I could the next day delete that, make that not happen, force that to be forgotten, I don't know where that's coming from. It's not a privacy concept, I don't think. I think it's sort of a policy idea that comes from this idea that maybe you ought to be able to hit the refresh button on your social media personality once or twice in your life. I don't know. But these things are not being thought through so that if I'm Brooks Brothers in my example, I'm now in a position where this law suggests that I would have to delete the most important piece of trade secret information probably in my portfolio, like what my customers are buying, that they are now getting the power to control, take that back, delete it. To me anyway, it's extreme. And I feel like we skipped the part where we said, oh, maybe we ought to just regulate businesses based upon the sensitivity of the actual information instead of having one law that sort of covers everyone. Clearly that horse is out of the barn, and the California contingency is very powerful in Congress, so the CCPA is now going to set a floor. And we'll see how much innovation on the internet really survives this. But I do think part of it, I agree with you, is privacy is an elusive concept for us. It's not, and I think we're just figuring out how to regulate it. For the young lawyers in the room, the students, this is going to be your lifetime. It's going to be something we figure out. And we are really at the beginning stages of it.
So I just want to echo, I do think it's certainly bipartisan. So another example is the Snowden report. After those revelations came out, there was a committee convened, very bipartisan, with some sort of far left and far right personalities, all of whom came to agreement on what the right response ought to be. So privacy tends to be bipartisan. It pulls off the charts, right? So most members of Congress want to act, well, not most, many want to act in privacy because their constituents believe in it. It's incredibly easy to say I believe in privacy without going the level deeper to say what that means. So that brings me to the point of why are there so many versions of this? Because privacy's actually kind of got a lot to it, right? It's not one problem with one answer. So some people care about data breaches, and some people care about the sale of information. And some people care about not having secret systems, right? And some people care about the right to erasure. And so I think that, there's been, frankly, a lot of problems in a variety of ways. And so members of Congress are hanging on to whichever one appeals to them. But again, we got a whole course on this, right? There's anyone out there wants to take privacy law? We get into all this. It's not a straightforward problem and answer. And I think that's why you see it playing out in such a complicated, incoherent way in various offices on the Hill.
I agree, it's multifaceted, and, one of the stickier issues that Seamus brought up, the right to be forgotten, or the right to erasure, I feel like there's something very American, right, about wanting to be able to reinvent oneself, right, and always believing in the power of rehab, rehabilitation, and, when you mentioned that's why we had it for credit histories, right, and that's got a financial, and you said, what's the corresponding harm, and then you mentioned your daughter applying to law schools. Certainly, right, teenagers, they post crazy things on social media, and, should that continue to haunt them as they apply for college, as they apply for jobs as adults, right? Should they have a right to hit the reset button, start over, and not have, those missteps dog them throughout the rest of their lives? So I think there is this part, right, that I think is deeply American. It's like we all deserve a second chance. We shouldn't forever be tarred by indiscretions that we made in our youth or even when we were adults. But there's trade-offs, right? Like, as with all values, they're not always in perfect alignment with each other, and we just have to make certain tough decisions as to what are we going to trade for this, and is this important to give up a little bit of that for?
Actually, it's my turn to quibble, which is, there's another American idea. So if you want to know, the right to be forgotten came out of a case about a guy named Costeja. He got behind on his mortgage. They published the foreclosure notice in the newspaper. He actually made good on the mortgage before they foreclosed, so it was never sold, but the notice is still out there, and it's embarrassing him. And the question is, it's truthful fact. And based on the Sorrell case in the Supreme Court of the US, it's very American, say you have an absolute right to speak truthful facts. And so this is sort of a weird tension, which is what lesson, I'm sure he's embarrassed by it, but on the other hand, the fact that someone went through some financial troubles, remained successful, becomes successful, is also part of the educative ethos of that. Whereas if we all have these sort of curated, sanitized versions of our lives where we've pulled all the bad facts out, systematically, there's another question about how that's going to turn out as well. Anyway, so Meredith, since you got us all here, you get a question.
Two questions. The first one I'm going to look at Seamus for, because I know we toss this around a lot. Obviously, in the privacy litigation landscape, we've seen the Telephone Consumer Protection Act with statutory damages of $500 up to $1,500 per violation. We've seen the Biometric Information Privacy Act with up to $5,000. We've seen the Children's Online Privacy Protection Act with no private right of action at all, so more restrictive than the CCPA, because the CCPA does open the door to some class action litigation on its face. We've seen COPA hijacked by the plaintiffs' class action bar in California to bring claims up for California intrusion upon seclusion, violations of the California Constitution. The AG has come out and said likely 3 to 4 enforcement actions a year. He has political ambitions, unquestionably. He needs this to work out. His office can't be embarrassed. They've staffed up to some extent. They've gotten additional budget. But at the end of the day, like you said earlier, the plaintiff's class action bar, whether it's the Leaf Cabraser firm in California or Jay Edelson's firms, with its office in San Francisco, is going to look to monetize this in some way. And in fact, they've come out and said in different forum that they actually are looking to get away from the traditional class action model and partner more with government enforcement to bring enforcement action. So my first question is, because I think compliance has to be with an eye towards risk mitigation. If you try to take the CCPA on its face and try to adhere to every single aspect of it at the outset, when it continues to be a moving target, you're going to be spending the $1 billion towards the $1 billion figure. But I guess I ask you, kind of, what is the likelihood that the AG will be able to find a way to outsource litigation, to partner with private class action lawyers? Have we seen this modeled before? And then my second question, which is a little bit unrelated, but something else that we toss around. I don't know if other people have thoughts, but generally speaking, I can foresee some constitutional challenges to the CCPA in various facets of the statute, whether it's the children's privacy piece, whether it's some of the issues that we talk about compelled speech and other things along those lines. So just wanted to get comments on that point as well.
So first, on the enforcement piece, there's a real proud history in California of the California AG not farming cases out to the private class action bar. And I think that will probably hold here, but I think it's going to be a limited amount of time as these rights find their way into our law in a significant way. You're going to have the combination of other states passing laws with broad private rights of action. And in California, I mean, it's inevitable, I think, that private right of action will come into force, or the local DAs will be given authority to support the AG. And once the local DAs are given authority, they do farm cases out to the private class action bar. And there's nothing worse than the combination of a private class action firm wielding the power of the government. You saw that in the tobacco cases, and so we may start to see versions of that as this law evolves.
Yeah, I'll just note that I've been told by at least 3 law firms that they've been speaking with trade associations to bring First Amendment claims. So I think we're going to look, and that's the other thing, is that we have a proud First Amendment tradition in this country that's just not there in other countries. So that very much comes into, into tension with these sorts of laws. But I do think we're going to see some litigation on that front.
There's definitely some preemption issues for different industries. There's a Dormant Commerce Clause challenge, I think, likely. There's Contracts Clause issues. If I'm a member of a loyalty club and I've traded information for discounts, this law says on a year look back, I get to delete that data and take it back. So interesting issues.
So before I let you all go, I'll give the panel any closing thoughts you wanted to share.
Look at me first. I don't know. I doubt every company is going to comply with every piece of this law, right? I mean, it's just really hard, and it's certainly hard to do it by the deadline. Kind of grab the positives, do real live risk analysis as to what matters to consumers, what matters to AGs, what can you actually fix, what can you do quickly. I think some combination of pragmatism and looking to the real spirit and intent of the law as another way to guide the next few weeks and months and beyond might help it feel a little less overwhelming and get you to steps that, make a difference and kind of do right by the consumers and by your organization.
Global companies need to fly high, meaning that they need to worry about the local laws, yes, but that's not where their obsession ought to be. Their obsession ought to be at a much higher level, to put in place a privacy framework with many of the basic principles, and we do see the basic principles repeated in every single privacy law: transparency, individual rights. Those are security. Those are repeated everywhere. So we need to put a framework in place such that with every new law that comes on the books, there's going to be some tinkering around the edges, but we're not going to have to keep reinventing the wheel every time.
First, I'd just like to thank the panel for giving me so much free legal advice. I learned a lot, which I'm going to take back to my team. And then the point about, 50 different states having 50 different laws, and then you making the global comment. So as a multinational company, we already grapple with the fact that the laws of the United States do not always perfectly line up with the laws of the EU or France, right? And when we literally sometimes have to pick our poison because there is just no way to comply with all of the laws of every jurisdiction in which we do business and operate. So unfortunately, that's just the reality. So I'm done with complaining about that. You know, we just deal with it. So, and there's just no way to lobby, you know, all of the foreign governments in which we operate. So I guess that's kind of my, you know, we've had to deal with this, you know, that's almost like the beauty of our government, right? That we have these states where they're the testing, what is it, the experimental, what's the phrase,
Incubators,
right?
yeah.
Incubators, right? So, I mean, this is kind of how our founders designed the system to work, right? So you have the states, they test these out, and then maybe, you know, then the federal government comes in. So, you know, I think it's just, it is what it is. You do what you can to influence, but now, you know, I think here we're just, you know, we'll do the best we can.
So if there's one thing that I would fix, and you know, I spend my life mostly in the California courts, and I don't know that you could have picked a worse incubator to sort of jump off this diving board.
We like incubators, just not this one.
Yes, this one is. So if there's one thing that I would fix, it's this tendency that legislators have to create a damages formula, $750 per violation, and the thought process seems to be, I want to make it enough money that a company would care about an individual consumer's experience. The problem with that is when you do the math for companies that have 70 million customers, these statutes turn plaintiffs' lawyers into Dr. Evil. And so you end up in mediations with statutory damage formulas in the billions, and it's just frankly ridiculous. So damage caps need to be looked at seriously, because you don't need an $800 billion lawsuit against Facebook if they've stepped out of line in a particular arena. That's just more than you need. Facebook's probably a bad example to use there, but you know, this affects real businesses. So if that's something we could fix, we're going to get through this a lot better, and we're going to have less wreckage on the side of the road.
Well, this has been a wonderful evening here on the panel. It actually continues, courtesy of Aiken Gump and Hutton Andrews and Kurth. They have generously sponsored a reception that will take place in the room outside. And so thanks to all of you, to those firms for making that possible. But most importantly, please join me in thanking the entire panel for coming.